video is self-explanatory. I wanted to record a video on this topic for two reasons. Number one, we cannot ignore the fact that advisors are transitioning, they're evolving, they're leaving their firms, they're taking deals, they're thinking about what's next for them. And so we can't ignore the fact that advisors are going to leave inevitably, not always, but where they may have started their career for the first 20 years and move on to something else. The second reason is because I have noticed, especially over the past year, how ill-informed and ill-prepared advisors are to actually transition, especially when they are taking the option to leave where they're at, i.e. a captive audience or captive firm rather, and go completely independent or RIA. And so I am of the belief that it is a firm's responsibility, no matter which firm, it's their responsibility to keep advisors happy, first of all, and to evolve with the business and evolve with advisors. But it's also a firm's responsibility to educate advisors on their options. There's no reason why we shouldn't help advisors understand what actually happens if they take a different step or pathway in their career. I obviously am very comfortable talking about these things. So I wanted to talk about some of the things that surprise advisors who leave we'll call it a captive situation. So maybe you're at an insurance BD, you're at a wirehouse, and you're looking to completely go independent RIA. If you are going to a firm, usually that firm can help you get organized and actually help you transition. But if you are deciding to go at it alone, you are going to be alone. So you need to make sure that you've done your due diligence, done your pre-planning, hired consultants to help you, and prepared you to take the next step to complete independence. So there's a lot of ways I can take this, and if I get good feedback, I'll record more videos on this topic, but I just wanted to highlight a couple things that usually surprise advisors. The first thing is that you absolutely need to find out or know whether your firm participates in what's called broker protocol or not. Broker protocol, for those who aren't familiar, it is essentially an agreement, and it began in the wirehouses between firm to firm, where firms said, look, we know advisors are going to leave us and go to you. And so we're going to pre-establish terms that we are comfortable with. In other words, information that an advisor can take from one firm to the other without getting sued. Now, there are lots of firms in this business. Many of the advisors who listen to my videos are at those firms that do not participate, which means that if you are to leave and go completely independent out on your own, your transition and the ease to which you can transition is contingent upon, number one, your employment agreement, whatever agreement you originally signed when you became a producer or registered rep of the firm. And secondly, in some cases, whatever your lawyer that you hire is able to negotiate with the firm you're leaving. If you are part of an institution where there are local agencies or offices, that decision point and that negotiation happens at that level. So what I'm saying is your relationship with your local leadership may play a role in how easy it is for you to transition out, or etc. Okay, so that's the first thing. So you need to really understand, what does your firm agree to in the industry, and how challenging is it going to be for you to leave? The other thing that's important to note is that a worst case scenario for an advisor, and again, many advisors don't know this, is that you break the terms of the contract, meaning you don't even look at the original agreement, you decide to just leave, you try to take your clients with you, and you get what's called a TRO. Essentially, that's a restraining order against your book. You'll have to go to court, you'll have to fight the firm to get clients. You may not win. Not a scenario you want to be in. So you want to make sure that you have retained legal counsel, that they've looked over your contracts, and that there is a plan in place for how you are going to exit and under what terms. Okay, so that's the first thing. The second really important thing to remember is that you may not be able to take any information with you. Yes, no information with you, meaning you're going to have to go through a process, and usually advisors will hire a transition specialist or transition consultant to come in and help them publicly source all of their clients' information. Because remember, if you're in a position where you are not allowed to leave you're allowed to leave, but not with any client information, you still have the ability to, in some cases, publicly source that on your own and get that information without, quote unquote, taking it from the firm that you were at. So it's really, really important that, again, you have an attorney, you go through your agreement, you come to an agreement on how you are going to leave and what you are going to communicate before you actually leave. By the way, none of this is legal advice. I'm simply giving you anecdotal information. Another thing that's important for advisors to think about is how you're going to communicate that you're transitioning, what exactly you're going to say, and how you're going to communicate it. Now, the day that you actually resign from your firm is not necessarily the day that you can leave and even reach out to clients. So critically important that you understand the difference between resignation date, garden leave, or quiet period, and the day you are actually free and clear. It is only after that day that you can, if that is per the agreement, reach out to clients and say, hey, guess what? I've gone to another firm, just FYI, wanted to let you know, et cetera, et cetera. My recommendation is that you use the time before you are actually gone to start drafting your communications. Perhaps you can record a video, perhaps you can craft a really nice email template that, after you've sourced all the public information about your clients, you can then send out and let them know that you're leaving. So let's assume you get past that phase successfully. Another thing to keep in mind is, if you have only ever been at one firm and you are going to an independent firm and you're changing custodians, that is a full repapering of every single client account, assuming that your clients come with you. Don't be surprised, by the way, if you let clients know you're leaving, or your former firm lets clients know you're leaving and they decide not to come with you. What I tell advisors all the time is, anybody who doesn't come with you because they want to stay where they're at, that's an opportunity for you to build new relationships with people who are more aligned with your values and the new brand that you have created. Full repapering, which means your new custodian is going to reach out to every single client with a DocuSign packet that clients are going to have to go through and sign all the paperwork. Really important, folks, that you let clients know exactly what's going to happen, and that, too, you are familiar with yourself with the process. Transitions are extremely frustrating. ACATing accounts, repapering accounts is an extremely frustrating process for advisors and clients. And I have found that the advisors who have the easiest time during that the actual transition are ones who are really familiar with every single aspect of it. So ask the custodian that you will be affiliating with, if it's a different custodian, what kind of emails are clients going to get from you? What email address are the emails going to come from? What exactly are clients going to be required to sign? In how many days from the time they sign are their accounts going to actually be opened? How are they actually going to be able to get in to access their accounts? All of these things are little things that clients will inevitably end up asking you. And it will be much, much better for you if you preempt all of those conversations by letting clients know that upfront, once they've agreed to come with you and have signed off and are waiting for the email from the custodian. The other thing I'd say that's really important is, don't underestimate clients asking questions that to us seem really simple. Questions like, what's the difference between a broker-dealer and an RIA? Are the policies and investments that you sold me 10 years ago bad? How do I know that the money is safe where you're going? When you go independent and you're no longer backed by a big brand, Some clients don't care, but some clients do. Some clients will say, well, you're going to this firm, never heard of them, it's a new name. Really important to explain the relationship with a custodian and the power of partnering with any of the great custodians that exist in our business. The last thing I'll say is don't be afraid to over communicate and communicate in a variety of methods: text message, videos, of course, all compliance approved. By the way, if you go independent, it doesn't mean you don't have compliance. It means you have different compliance people. But don't be afraid to communicate to different segments of clients in a way that is most comfortable for them to communicate. So the first day you leave and you source that information, yes, it's going to be pounding the phones and calling every single one of your clients, but it may also be sending emails or text messages or posting things on social media. So my recommendation: hire an attorney, pull your employment contracts, be prepared for all of the things that are going to happen. Don't be afraid to over communicate with your clients, and even maybe send them a timeline so that they can envision what this process looks like for them and for you from beginning to end. Okay, I hope that was helpful. If you did find this valuable, let me know, and I will record more videos on this topic. I will see you next week, same place, same time. Take care.